place you really have to go and follow is at Deborah Abalaba. We already have OCJ Okocha on the other side, and you all know him. He is a member of the Order of Niger, and then he's also a SAN, that's a senior advocate of Nigeria. He's also a justice of peace. He's a former president of the Nigerian Bar Association. So many caps. He's been also an attorney general of Rivers State. So much. His CVs are too long. I can't go into them, but we all know OCJ Okocha. When it comes to legal practice in Nigeria, he's been well over 40 years at bar. And so when you talk about the name, of course, everybody, we can almost relate. Good evening and welcome, sir.
Good evening.
We've actually talked with Honorable Victoria Wobonyeche on the other side, and we're looking at, she was actually excited about the fact that there is this executive order, because according to her, it was a plea made to the president to say, let there be the implementation of this order where we can actually have an independent legislature, and there are checks and balances, and of course, separation of power from the executive, the judiciary, and the legislature. So what is your take on this executive order? Do you think it makes any difference, going by the fact that the Constitution is yet to be amended? Do you think, and I'm going to read something for you. I think you were not on when I read it. I will read it for you so that you can understand where we're coming from. This is the news that announced the signage of this executive order into law by President Muhammadu Buhari. And I'll read it to you, sir. Part of this is that any state that refuses to adhere to their autonomy, that is to say, allowing these people have whatever is due to them completely, they would have the Accountant General of the Federation deduct the money from source. That is to say, before this allocation gets to the state, it would have been deducted already. And then I'm also going to read, the Minister of Justice talking now. He said, consideration was given to all other applicable laws, instruments, conventions, and regulations that provided for financial autonomy at the states. What is your take on this, sir?
Well, you know, we've always clamored for there to be independence, financial independence for all the arms of government and for the local governments throughout the Federation. The reason being that by so doing, you can secure their independence and their ability to function. Because without funds, allocation of money from the Federation account, and also from the Joint Allocation Committee of the states, because internal revenue is also supposed to go to the local governments. But the necessary amendments need to be made to Constitution. I don't think it will be something that ought to be done by executive order, because we can run into difficulties with executive orders. What if the Attorney General does not proceed in the manner expected? This is a provision which I think ought to be entrenched in the Constitution, so that everybody will know that he or she, in whatever office, Accountant General of the Federation, the local governments themselves, the Attorney General himself, all have an obligation to comply and to disburse those funds directly to those various tiers of government as we desire. But I don't think an executive order alone can do it, because it can put us into difficulty. I ought to have been with me here, the Constitution. There is a specific provision that deals with it. I think it's section 162 or so. So I believe that we need a constitutional amendment to secure what exactly is intended to be achieved, which we all agree would be very, very helpful for local government administration in Nigeria.
Okay, so are you saying that without a constitutional amendment, first of all, I think you should educate the public what an executive order entails. That way they might be able to flow with your reasoning on the fact that there's need for an amendment. What is the difference in amending a constitution to suit a purpose and to enshrine an executive order as a way of enacting a particular law that the constitution might have a contrary statement about?
An executive order is not a law. It is just a directive. A constitutional provision is a binding obligation on all the tiers of government, all the arms of government. And we say that they are entrenched provisions, and nobody can go contrary to those provisions. An executive order is just an order made by an executive authority. In this particular case, we are talking of the president. In recent times, we've been talking about the executive orders dealing with this COVID-19 and coronavirus issue, where various governors, even the federal government, through the president, has issued certain orders. They are directives. And of course, when there is a directive, it's expected that those concerned will comply. But they are not, you know what I say, effectively binding as a constitutional provision. That is a little difference that I want to make, and I hope that the listening public will understand it from that point of view.
Okay, in other words, are you saying that governors can choose to contest, they can actually choose to contest this executive order in court, in a court of law? Is it possible? Listen, if they contest, do they have a chance of?
Everybody is happy if they will have this kind of situation in Nigeria where the Constitution obliges the Accountant General of the Federation to remit funds directly to the local governments. It's already there that they should remit funds to the tiers of government that are entitled to benefit from the Federation account. But it is not being done. And until it is effectively entrenched, that is to say, a specific provision must be made for it in the Constitution, then there is an obligation on the part of the Accountant General of the Federation and the Attorney General of the Federation, who apparently the President in this executive order has given directives to ensure compliance. So constitutional amendment will give it the necessary authority and enforceability that we all desire.
Okay, so pending when there's a constitutional amendment, your take is that it is not law yet.
Yes,
the executive order does not stand, cannot stand. What?
It is not a binding law. It's not a law. An executive order is not a law at all. It's just a directive.
Okay. It's just a directive, okay?
Yes.
All right. So basically, let us also look at the judiciary. Even though you have this angle of it that says an executive order cannot actually supersede what the law says about a particular thing. If the law has stated, as amended in 1999, that the control of funds as regards to judiciary and legislature lies in the hands of the state government and the 36 states of federation, what that means is that it stands, even though the president has said he has looked at the applicable laws, he has looked at the instruments, he has looked at the conventions, and he believes, he quoted 121. I think 121 subsection 3, he quoted that as what gives him the rights to enact this executive order. Going by this, he's enacting this, and it is taking effect immediately. So in other words, you're saying that we don't have it from your angle as a lawyer and from your knowledge of the Constitution, you're saying if the Constitution says something different, it cannot stand.
No, anything contrary to the Constitution will be null and void to the extent of its inconsistency with the Constitution. You understand? Now, let me tell you this. The allocation of funds to the judiciary is provided for from the Consolidated Revenue Fund. And it is not the governors that allocate funds to the judiciary. The judiciary's funds ought to be allocated direct from the Federation accounts to the heads of the various courts in Nigeria. But this is not even being done because we observe our Constitution in brief. That's why we've been calling of judicial autonomy, judicial independence for so long. So unless these provisions are clearly stipulated in the Constitution and the particular authority who is obliged to carry it out is given that mandate in the Constitution, it will be difficult to effectively achieve what we want to achieve. Independence of the judiciary, independence of the local government areas in Nigeria.
Okay, going by what you said, I will look at the coronavirus period, all right?
Yes.
We have freedom of movement. Because I
Yes.
remember when you started talking, you said there's an executive order. Executive orders have been flying around here and there since the COVID-19 period. Okay, so it
Yes.
means that what that means that we've had one or two executive orders that contravened what the Constitution says about certain things. I'll give you an
Yes.
example. We have a freedom of worship, freedom of
Yes.
movement, freedom of association.
Yes.
But during the coronavirus, you understand, there
Yes.
was there's an order right now that says you don't go close to someone. You have to give like 1-2 meters away. There are
Yes.
restrictions. You can't go to church anymore. A
Yes.
particular number have to be. So our rights have been contravened. But there's a
No,
section
no,
of the
no, no,
Constitution
no,
that
no, no.
gives the
Not
president
contravened.
the right.
Not contravened, but limited. Limited. There's
Limited.
no
Okay, let's say
unlimited
limited.
rights. Yeah, there's no
Okay,
unlimited rights in the
let's say
Constitution.
limited. But
Yes.
sir, hold on, please. Let me
Yes.
finish my thought. What I'm
Yes.
trying to say is that if I cannot go to church, maybe I get to my church and then there are 50 people there already. At that time, my rights has been contravened, not limited, because I can't go in at all.
No, no, no. I don't agree with you. That's
I
not
can't go into
what.
church.
Yes.
But let's get to the point I'm trying to make, sir. What I'm trying to say is, if
Yes.
there are certain laws already right now that have been shifted aside and an executive order is taking premise, does that not say the executive order can actually stand in scenarios?
Let me explain to you. There's no unlimited rights in the Constitution. Each of these rights, freedom of religion, freedom of worship, freedom of movement, can be curtailed, can be
Okay, when
limited.
you finish, it will come in.
Yes, can be limited. Because it is said so in the Constitution that these rights are subject to any other regulations that will secure good governance in Nigeria. Freedom of movement, for instance, can be curtailed. If for any reason you have committed an offense and you are tried, then you are imprisoned. Because this is another limitation of that. Now, take your issue of religious freedom and religious worship. The fact that there is a pandemic now ravaging the world, the president, under the Quarantine Act and all such enabling instruments, can issue these orders to say, well, I didn't say don't continue to worship, don't continue to go to church. All I said is that limited numbers of people should be in those churches. You understand? So the right is still there. But in order to secure good governance and the safety and security of other persons in the state, these rights have been limited to that extent. That is what I'm trying to explain.
Okay, just hold on. Honorable Victoria Nwobonyeche is on live on Facebook. She wants to add something to this topic that is being discussed. Just hold on. Let's hear what she has to say. Go ahead, Honorable. We're listening to you, man.
Good evening, the Senior Advocate of Nigeria. I'm just a little bit confused, and I would like to get some clarifications. Because I know that as a legal luminary and authority when it comes to legal practice, I had heard over the radio, I heard over the radio saying that the executive order by the state government was a law, and it was in order that it was.
I never said it was a law. An executive order cannot be a law.
Yes. So I'm just wondering whether the orders differ. When an order is made by Rivers State government, it has the force of law. Then when it's an executive order from the federal, now lacks the force. I would just like to get that clarification, if you don't mind.
No, I don't mind. You remember I said that under the Quarantine Act, certain regulations can be issued and orders made to restrict people's movements, to restrict operation of certain businesses. And Deborah was just asking me about limiting people's rights to go to church. As under that act, the Quarantine Act, Both the president and the governor are entitled to issue executive orders. And these orders have been issued. They are not laws, as I say. But when these regulations are issued, it is expected that people will comply with them. So in a way, they are also binding because they are issued in furtherance of an existing law. The executive order relating to disbursement of funds direct to local government, I remember you were a very, very strong legislator here in Rivers State. Once these executive orders are issued, they should be complied with. And anybody who feels he has difficulty complying with them can go to court to challenge them. This is the point that I made when I was talking about the issue of executive order issued pursuant to these restrictions because of the coronavirus pandemic. I hope I'm clear.
Okay, so let me get you, sir.
Yes,
ma'am, you want to ask another question, or should I come in at this point?
Another thing, you know, the constitutional amendment has, you know, the 1999 constitution has already been amended to give, you know, financial autonomy to the judiciary. So I don't even see that the president is the one that is granting them autonomy. The constitution has already granted the autonomy. From my understanding, I might be wrong. That's one thing I would like him to get. I thought that the president was implementing the constitution, was trying to, you know, give an administrative order to ensure that the constitutional provisions are carried out. And if there's a default, that the deductions will be done from source. You know, because that section 121, subsection 3, I thought that was the provision that there is already autonomy, but there's not the implementation of that autonomy. So I would like to be properly educated by our legal luminary.
Yes, Victoria, my sister, if I may call you that, the constitutional provision is there that funds belonging to the judiciary should be disbursed direct to the heads of court. But this is not being done. As I say, I recall that you were a legislator. Because you see, their funds, particularly the funds covering the salaries of judges and justices, are paid directly by the National Judicial Council. So to that extent, you've secured some of their independence. But they still need some additional funds, capital development, roving allowances, and so on and so forth from the states. And when these do not come, the judiciary is in a way incapacitated. Now, if the president is making an executive order directed at the Attorney General and the Accountant General, that will not necessarily cover all the funds required by the judiciary. It will also not cover the funds required by the local government, because it is actually local governments that we are focusing on before we now took this extension into what should be the independence of the judiciary. So these are provisions which we say should be clearly stated in the Constitution. And the person with responsibility underscored in the constitutional provision so that there is no deviation from any of those provisions. That is the point I'm trying to make.
Okay, I'm looking at the discussion so far. What it means is, yes, the executive order has some kind of backing of the law to be issued.
The president, as executive authority, he represents the executive, can issue executive orders. The question is, how effective will be the implementation of those executive orders? And, you know, as somebody just asked, it's either you or Victoria, does it mean that anybody can go and challenge that executive order? And I said, yes, because it's a...
Hello, we can't hear you anymore, sir.
I said, can anybody go and challenge an executive
I guess it's network.
Yeah, but we'll get him back, don't worry.
Yes.